In chapter 9, we're going to talk about ending a contract, when a contract ends, and we're going to talk about remedies available when there's a breach of contract. Why is it important when a contract ends? Why is it important to know? If you are a party in a contract, why do you think it's important? The deal is complete. Because the deal is complete, in principle, there are no more pending obligations. You're fine. You're released, right? So yes, that's the main, one of the main important aspects why knowing the end of a contractual relationship is important. So a contract will end, and by the way, the textbook also we also use in legal terminology, discharging. Discharge is to end a contract. So you should know this. A contract will end or will be terminated. The most common way will be by performance. You buy coffee, you pay for coffee, they give you coffee, ended. Agreement is ended. Both parties comply with their obligations. But not all the time performance is satisfactorily. So there may be issues with performance. So we're going to look into these. A breach. Sometimes a contract will end when there's a breach. But sometimes the contract doesn't end when there's a breach. So we'll also look at those details. A contract may end by the agreement of the parties. Well, parties are in an agreement relationship, and they sit together and they negotiate to end the contract. It's possible. And the last one is frustration. So frustration is not the feeling you have when you are in this lecture. No, it's not this. Frustration is a legal term, is a legal concept, and I will explain to you what frustration means. Okay? Because contracts may be frustrated, and when they are frustrated, they are terminated. Okay, so we'll see this in a minute. So let's start with performance. Well, termination by performance or discharge by performance is when parties or each party will satisfactorily complete their part of the bargain. Isn't it the coffee example? You order coffee. What's your obligation by ordering coffee? Pay for the coffee. What's their obligation? Give you the coffee. So when each party satisfactorily perform their obligation, contract is ended by performance. It may be the case that there's a minor breach. We'll discuss this in a minute. What I want to call your attention to is to substantial performance. Sometimes the contract is substantially performed, almost fully. In those circumstances, and they will vary on a case-by-case basis, it will be considered performed. So substantial performance is performance. The example here is you ordered 10,000 liters, you only got 9,900, almost there. So the contract was substantially performed. You could sue for the difference. You would ask for a discount in the difference, but we consider this as an example of substantial performance. Are you following? All right. There's standard of performance. What is standard of performance? It is an attempt to perform. So a party attempts to perform as agreed based on the terms of the agreement, but they cannot. So let's say I hired a gardener to come to my house this afternoon. The gardener just got at my house and there's nobody there. The gardener cannot perform. But it's not because they don't want, it's because their performance is being refused. No one at home. So this is an example of tender of performance. When a party attempts to perform, tries to perform, but their performance is refused. So in those situations, that party, they are relieved from their obligation to attempt again. They don't need to perform. Or in other words, the contract is ended because they attempted to perform, but their performance was refused. Not only do they not need to perform again, but they can also sue for damages. What if the gardener rented equipment, machinery? What if the gardener hired hourly employees? They would suffer damages. So the contract ended for them, or the contract actually ended, and the victim, the gardener, they can still sue for damages. So that's standard of performance. But as it is usually the case in law, there is an exception. The exception is regarding payment. When payment is made, or when there's an attempt to make a payment and it is refused, the obligation to pay is still there, is not relieved. But now it is the creditor's job, the creditor's obligation to collect the payment. Okay? So when the obligation is only payment, when there's standard of performance, the contract does not end. But it ends if it's anything different from payment. Is this clear? Okay, that's important to know. Some obligations will continue after the contract is performed. This is mainly related to the Sale of Goods Act. This is related to consumer legislation, consumer law. So you buy a laptop, you pay for the laptop, they give you the laptop. In principle, the contract is ended. What if the laptop doesn't work as a laptop? What if the laptop is defective? What if the laptop explodes or causes any other damages? So there's legislation, there's law that say that some obligations, they survive the end of the contract. Okay, so keep that in mind, that in some circumstances, mainly with regards to the sale of goods, with regards to consumer legislation, some obligations will still survive the end of contract. Question for you. Just give you a tip. Forget about D, because I will explain D in a minute. D is not right, but I'll let you know in a minute. Which one is right? B, Bob?
B or
B or
C.
or C? B or C? Okay. Well, let's do it together. If a person owes money, has attempted to pay, reasonable way, as agreed, reasonable time, payment has been refused, they are free from any further obligation to pay. Is this right or wrong?
Wrong.
That's wrong. Tender of performance with regards to payment, the contract doesn't end. Obligation doesn't end.
Yep.
B, when a person attempts to perform according to the contract, buyer refuses, the person attempting could sue the buyer and the contract would end to them. So they would have no further obligation to attempt to perform. Is this right or wrong?
Right.
That's right. That's tender of performance. You try to perform, performance was refused, Contract is ended to you. These the right one. C, seller attempts to deliver the contract goods, time and place designated. Buyer refuses. Seller will have to make another attempt. No, that's the opposite from B. If you attempt to perform and performance is refused, contract is ended for you. Right? And D is wrong, but I'll get back to this D in a minute. Are we good? So what was the issue here? The issue was to know in what situation the contract would end. What situation there would be tender of performance. And the situation is B. So now let's look at breach of contract. So breach of contract means a party improperly or incompletely perform their obligations. So you ordered coffee. So you ordered small coffee. No, better. Big coffee. How do they call it? It's small, medium, large. Yes, large. Thank you. So you order large. They give you small. Isn't it a breach? And again, I'm going simple in examples, but if you think about a business transaction, you order goods, goods are defective, or you order service, web development, a website for your new business. There's a deadline, and the deadline is not met. It's also a breach. There should be a contact form in the website, and they do not develop a web form. It's also a breach. So whenever performance is improper or incomplete, there may be a breach. Another way a breach may happen is also when the party refuses to perform. So refusal to perform would be the party calls you or writes to you and says, hey, we are in an agreement for this service, but I'm not able to deliver it. They are refusing. So it may also be a breach. So let's look into details about breach, because some breaches, some types of breach will end in agreement, but others will not. So we should know. Well, we just saw in a question warranty. So here I told you I would explain in a minute. If a warranty is breached, so what is a warranty? Warranty means a minor term in an agreement. A minor term. Minor term could be 1% milk or 2% milk. They're milk. What differs? It's minor. But I will give you another example. And conditions. What are conditions? Conditions, they are major terms. So we must know conditions and warranties, because when a condition is breached, the contract ends. But when a warranty is breached, the contract doesn't end. So major term, minor term. Let me give you this example. I bought a Porsche, and when I went to take delivery, I bought a 911. They wanted to deliver me a Porsche Carrera. Is it a breach or not? I ordered a 911 Porsche. They wanted to deliver me a different one, Porsche Carrera. Is it a breach or not? Yeah. Yes, it is. Is it a minor term or a major term that was breached? It's major. It's a major. It's a different car. So a condition was breached. So I told them, hey, give my money back. Contract is ended. That's a major breach. Are we good? Now, I ordered the same Porsche 911, fully loaded, and at the moment of delivery, I wanted black, but they delivered yellow. Is the color a major or a minor? You're thinking about a Porsche. No, think about any car, but I'm just exemplifying as a Porsche, but is the color of a car a major or minor term?
It's a major, but it can be changed,
It's a major.
but it can be changed on customers like demand.
Yeah, I know it may be changed, but why is the color a major term?
Because the terms of the contract said it should be black.
No, I ordered a black, but I did not specify that black should be a major term. I ordered a black Porsche 911. The color of a car. So we just went through the example in which a different car, the 911 and a Carrera, they would be a major breach. What about the color? It's minor. What about the type of the wheel, the rims? Minor. Because it's still the car I wanted. It's still the same engine, same car. But that's a very good point, because if I want it black, no matter what, then I can make it express in my offer that it has to be black. If I make it express, what I'm doing, I'm making a minor term to become a condition. Then, if they breach that condition, I am relieved. Does it make sense? So with this car, they come with a yellow one, minor term. And okay, some people could regard this as a major, but let's take color of a car as a minor term. The contract doesn't end. I have to go ahead with the deal. I need to buy that car, the yellow one. I may sue for damages, I may get a discount eventually, but the contract doesn't end. As opposed to when a condition is breached. Does it make sense? So again, you order coffee, 2% milk. They give you coffee, 1% milk. Minor or major? Minor. There's still coffee and milk. You order coffee, they give you tea. Minor or major? Major. And I'm saying minor or major, but remember, major will be a condition. Whenever a condition is breached, contract is ended. Warranty, minor. Whenever a warranty is breached, contract is not ended. So coming back to that question, if a warranty is breached, the victim has no further obligation to perform. Is this true or false?
False. That's false.
It's false. You just saw it. When breach, performance is still required. Okay. Exemption clauses. So exemption clauses are those clauses that attempt to limit or eliminate liability. So when we discuss tort law, I told you that we would go to a ski resort and we would sign a waiver. The waiver is an example of limiting or eliminating liability on the ski resort. So if those waivers, they are challenged in court, courts will interpret them strictly. And they may be effective if they are brought to the attention of the party signing it. So that's why before going to the ski resort, if we sign up online, they will send a link for us to review the waiver and sign before getting to the ski resort. And we cannot start skiing or snowboarding or snowshoeing if we don't sign the waiver. Another example would be of an exemption clause. So you go to Best Buy, disclaimer here, not sponsored by Best Buy, just an example. So you go to Best Buy to buy a laptop and you see a laptop on sale, promotion. But it is on sale because the item that is being sold is the display item, out of box. So there may be minor scratches, keyboard may be dirty a little bit. So if they want to exempt themselves from liability with regards to those small scratches and dirty keyboard, they need to bring this to the attention of the customer. And then they will say final sale, display item. If they don't bring this to the attention, they cannot have their liability limited or eliminated for these. Are we good? So those are the exemption clauses. Parties cannot use the exemption clauses if they make the bargain unconscionable. So the same example, Best Buy cannot say, hey, because this is a display item, this laptop may not function as a laptop. No, I'm buying a laptop because I want to use it as a laptop. So the main nature of the bargain cannot be exempted. Okay, so even though it's a final sale, if the laptop doesn't function well as a laptop, I still have remedies. Okay, regardless of the exemption clause. Fundamental breach is the breach that goes to the very root of the contract. Again, you order coffee, you get tea, so there's a fundamental breach. You are not getting what you bargained for. Now, refusal to perform. So another way there may be a breach in a contract. So we saw breach as a breach of a condition, ends a contract. Breach of a warranty does not end a contract. And now let's look at refusal to perform. Refusal to perform is also known as repudiation. So this technical term you should know. It's either refusal to perform or repudiation. So the gardener example. Called the gardener yesterday. We came into an agreement that the gardener would come this morning, but the gardener didn't come. So they refused to perform. Or they called me this morning, 6 a.m. and said, hey, I'm not coming. I can't come. So sometimes this refusal to perform takes place before performance is due. And if it takes place before performance is due, this is called anticipatory breach. So it's a breach that takes place in an anticipatory way. It's anticipated. It anticipates performance. Why is anticipatory breach important? It's important because I don't need to wait as a victim. I don't need to wait until performance is due. As soon as I learn about anticipatory breach, I can take action. And what action can I take? Well, I can accept the refusal, and then I can sue for damages if I suffer or incur any damages, or I can insist on performance. Is insisting on performance is not going to the gardener's house and threatening the gardeners to come. Insisting on performance is suing in court for performance. Okay? So I can choose any action I want to take as soon as I learn about anticipatory breach. And once I make a decision, that decision is binding. I cannot change. So if I accepted the refusal and I may sue for damages or not, I cannot insist on performance later on, and vice versa. If I insist on performance, I cannot accept this. So that's why anticipatory breach is important. So summary here on breach, and now question for you. Which one is correct? A. When a condition is breached, is a condition a major or a minor term? It's a major term. When a major term is breached or a condition, the victim can treat the contract as ended. That's true. That's how it is. Let's look at the other ones. How about C? When a warranty is breached, warranty is a major or minor? Minor. When a minor term is breached, the contract is not ended. That's the yellow portion. Example. When a condition is breached, a person can only sue for damages but must perform. No, this is wrong. This contradicts A. When a contract is breached, the warranty will require, well, warranty here is being used as guarantee, not as a minor term. It's just trying to confuse you. When a contract is repudiated, so refusal to perform, before performance is due, the victim must wait. Do we need to wait until performance is due? No. How do we call this? Anticipatory breach. So this is an example of anticipatory breach. Are we good? All right. Now discharge or termination by agreement. Well, this is easy, straightforward. I have a contract with BCAT to teach this course. This course goes to the end of July. Let's say I want to travel in July. I want to finish this contract by June 30th. So BCAT and we could sit and come to an agreement to end the contract, not by the end of July, but by the end of June. That's it. But there's something we need to be cautious about, which is the mutual benefit. What is a mutual benefit in law, in contract law? How do we call mutual benefit? Both sides must derive a benefit. How do we call this in law? I heard? Consideration. Yes. So the key aspect here is about consideration. Modifications, they require a fresh consideration. So if BCAT agrees to end the contract June 30th, who's getting the benefit? I am, because I want. They are not. So what benefit can I offer them so that consideration is valid? Maybe I'll return some money, I refund them, or I'll teach for free, or I'll teach those classes again another time. So I need to offer. So that's the key point. If there's a one-sided discharge, one-sided termination, so if BCAT and I don't agree, but then when it's July 1st, I'm in Hawaii. What is this? It's written there. What is this? It's a breach. If only one side terminates the agreement, it's not a termination by agreement. It's a breach. Because BCAT didn't agree. So, and I went to Hawaii. So it's a breach. Okay, there's no unilateral discharge. There's something that is accord and satisfaction. Well, you don't need to focus on this, but I want to mention this to you. Accord and satisfaction is when parties are agreeing to end a contract based on another benefit. It's like a settlement. So the best example here would be, we were in a loan agreement. You lent me 10,000 and I defaulted payment. I didn't have money to pay you back. So you are losing 10,000. Now I offer to pay you 5,000. Well, 5,000 is less than the original amount. In principle, there's no fresh consideration here. No fresh mutual benefits. However, in principle, because however, you were getting nothing, zero. Now you are getting at least 5,000. So courts, they accept getting less to satisfy a debt. They consider this to be fresh consideration, valid consideration. And this is also known as accord and satisfaction. You don't need to memorize this for exams, but I'm just mentioning to you that it is an exception on the fresh consideration aspect. Now, novation. I told you I would discuss about novation today. So what is novation? Novation is when one party of the agreement is replaced by another. When does this happen? Does anyone rent a property here? Is anyone a tenant? Okay, you are. Let's say your landlord, the owner of the place you rent, let's say they sell the place. The buyer will become your landlord, right? That's novation. One party is replaced by another. The old party is relieved from liabilities. The new party will get the liabilities from that time on. That's novation. When a company is purchased by the other, let's say Starbucks purchases Tim Hortons, or Tim Hortons purchases Starbucks. So Tim Hortons purchasing Starbucks means that the employer of the employees was Tim Hortons. Now, sorry, was Starbucks. Now they will be Tim Hortons. There will be innovation in the contracts. Okay, so that's what novation is. Question for you. What do you think? Which one? D? D, Donald? Yeah. Okay. Yeah. Do you agree? D? Fred no longer wants to honor the contract to sell the printer, but tells he will substitute for a 500 bolt. Mitra agrees. So there's a change in the contract and the bolt. There's a new benefit here. So Fred doesn't want to honor the contract with the printer, but has offered the bolt. Mitra is okay with the bolt. So this one ends a contract. When they perform, the contract ends. Well, this one is not right, because the replacement here is valid consideration. E? B? Meaning Miki agree, meaning we'll take less as a full payment. Miki will pay her 2 days early. Well, less and earlier. Not only about agreeing, but also there's mutual benefit. And because of accord and satisfaction, it's possible to get less to satisfy a debt. So B does end a contract. Does it make sense? C, model proposed building for architects who were to meet with their clients March 10. The model was destroyed the night of March 9. Car left the road, crashed into the workshop, destroyed the model. Destruction of the subject matter. What is this? Frustration. It's close to frustration, but it's not frustration. We saw this last class. when my Porsche caught fire in the parking lot.
Yeah, should be mistake.
Shared mistake. Contract is ended. So it's not B, it's not C, it's not D. It's either E or A. E. Which one? E. New car is delivered. The seats are cloth rather than leather.
That's why it's a breach of warranty.
It's a breach of a warranty. When a warranty is breached, does the contract end? No, it does not. So that's E. And I didn't make it clear to you, but it's important to mention on A. Buyer and seller agree orally to cancel their contract. Well, if the agreement is orally or in writing, doesn't matter. They are both valid. But neither one had performed their obligations yet. So if none of the parties has performed their obligations yet, yes, they can agree to end the contract. And then no fresh consideration is needed because no one has performed yet. Okay, so this also ends a contract. E is the right answer. Is this clear? Bit more complicated, but yes, we went through all the situations in here and checked whether the contract could be ended or not. Are we good? All right. So it's important to see now conditions subsequent. We have already seen conditions precedent. Conditions precedent. Remember when we discussed about purchasing real estate? Subject to offer. So I will buy this house if I can secure mortgage. So only if I secure mortgage, then the contract starts. So a condition precedent needs to be met or waived so that the contract starts. So this is just a review. Now, what is new for us is conditions subsequent. A condition subsequent is an event or a condition or situation taking place in the future that will end the contract. It's very simple. A friend of yours or family member, they say, I will pay you a monthly allowance until you graduate PCAT. So, will you not graduate PCAT in the future? Will you or will you not? You will. So, when you graduate, the contract ends. What contract? The allowance to be paid, monthly allowance. Right? So the situation has to be met or has to take place in the future. Then the contract will end. Okay? That's what a condition subsequent is. There may be a question related to either conditions precedent or subsequent in your exam. So you should know. Force majeure. Force majeure is a type of a clause or section in which parties will try to foresee, to anticipate events that may cause their performance to be difficult or impossible. This force majeure clause is very popular now after COVID, because parties are now adding a pandemic to their force majeure clause. In a force majeure clause, parties will say, for example, if there's a strike at the port, the buyer does not need to pay for imported goods because they don't have access to the goods until the goods are cleared customs or are sent to them. So situations in which performance may become more difficult, may become impossible, they will be dealt with in a force majeure clause. But in a force majeure clause, they will anticipate what those situations are. Could be, as they call, acts of God, flooding, hurricane, volcano, snowstorms, could be strikes, could be fire, wildfire, etc. Okay, so that's why this force majeure has become very popular nowadays after pandemic. When something is not anticipated in a force majeure clause, they may be frustration. So frustration is the last of the 4 ways a contract may end. We started discussing that a contract may end by performance. A contract may end by breach, but by breach of a condition, not a warranty, or refusal to perform, anticipatory breach. A contract may end by agreement, and now a contract may end by frustration. What is frustration? It's an outside. What does outside mean here? Outside means out of the control of the parties. It's an outside, unforeseen event, which makes performance impossible. So when COVID hit back in March 2020, pandemic was declared. Could anybody foresee a pandemic happening? No. Was it related to the parties or out of control of the parties? Out of control. So many performances that were impossible, they could be regarded as frustration. But performance has to be impossible, not more difficult. There's case law here, 2021. This travel agency based in Vancouver, they dismissed an employee. The employee sued for wrongful dismissal. In their defense, the travel agency said, no, because of COVID, the employment agreement was frustrated. The court said, no. It was not impossible for you to sell air tickets because there were some people traveling. Yes, you were selling very few of them, but still it was not impossible for you to run your business. And by the way, you hired someone in this time. So again, frustration. Performance has to be impossible. Let's say a good example would be, well, with pandemic, there were several, but a good example would be American lettuce. So let's say I am a farmer, I sell American lettuce, and let's say the Canadian government prohibits American lettuce because of a bug, temporarily, because of a bug. My performance to deliver American lettuce to you as a buyer is impossible. It's prohibited. I can't. So it's an example of frustration. Okay? If one party causes the issue, it's not frustration. It's going to be negligence, eventually a breach. So if I cause my product to be destroyed and then I cannot deliver it to you, it's not frustration. It has to be outside of the parties. Last example, airplanes flying from Europe to Asia. I heard or read they are not flying over the Ukrainian airspace because of the war. But it's not impossible to fly from Europe to Asia. It's more costly. It takes more time because they now go through the North Pole, I believe, or Russia or Middle East. So it's not frustration because it's not impossible. Okay, so keep in mind, it has to be impossible. All right, so now I want to check these situations. In which situations there was frustration? Which one? B, Bob. You agree? Disagree? Give a lecture. Well, it's not saying it's an in-person or online, but let's consider it's in person because those questions were created before the pandemic. So give a lecture at a convention, but the convention is canceled because of an epidemic. Is an epidemic foreseen? No, in principle not. Nowadays, they may be through a force majeure clause, but in principle not. There's a pandemic. It is canceled. Was it canceled due to McGee's conduct? No. Outside, unforeseen. Performance is impossible. Yes, B is the correct one. Okay? Performance here is impossible. Let's look at A. Deliver 10 bushels of ripe tomatoes, but the crop is destroyed by hail. Is hail foreseen when you are a farmer? It kind of is. If you are a farmer, hail may happen. So it's not unforeseen. But not only this, even if it were unforeseen, before delivery date, the supplier here, they could get tomatoes from other farmers and still deliver. So it would be more costly, more difficult, but not impossible. That's why A is not correct. C, sculptor lost control of the car, had been drinking heavily. Was it outside? Not outside. It was caused by him because had been drinking, was drunk. Purchase a business, but the buyer suffered loss in the recent stock market crash. Is a loss in the stock market foreseen? Yes, it is. It's possible. Actually, when we invest in stocks, the only certainty we have is about the loss. We don't know if we're going to make money. So it's foreseen, and yet the buyer could still get loans in banks, get money from friends, etc. So they could still go ahead with the deal. That's why this is wrong. And E, McDonald agreed to buy Thornburn's horse, unknown to both of them. At the time the contract was made, the horse was dead. Destruction of the subject matter. Shared mistake. What is the difference between shared mistake and frustration?
Shared mistake, no party is aware of it, and it will be too.
No one is aware of it. It's fundamental to both, and it's at the time the contract is entered into. Frustration after the contract was entered into, because it then makes performance impossible. Are we good? All right, let's break. Okay, so when there's a breach in a contract and a party suffers damages, the victim, the non-breaching party suffers damages, they may seek these damages in court, compensation for those damages in court. So here, what we need to understand is that damages in contract law, they have a different perspective from tort law. So in tort law, let's say in an accident, I had my arm broken. The money I will get will be used for medical costs. To have my arm back how it was before the accident. Does it make sense? So my arm will be fixed in a way as it was before the accident. So in tort law, we say damages look backwards. In contract law, damages look forward. Why? Because damages in contract law will be as if the contract had not been breached. So let's say I buy goods. I buy laptops for 100 and I sell for 150. But because the laptops are defective, I cannot resell them. So what losses am I incurring? The profit I would make. The profit I would make had the contract not been breached. So this is just a perspective I want to share with you. In general, damages in contract law, they will look forward. And in tort law, they will look backward. Okay, so this perspective is important to know. And then this is just a review. In contract law, we also have the special damages available, the general ones, and the punitive available. 3 of the main one, even though there are other types of damages available as well. But this is just a review. But now we look at some limitations, and they are similar as they were in torts. Not the same, but similar. Well, with regards to remotedness, damages, they will not be available for unforeseeable losses. Okay, so I supply coffee to your coffee shop. I failed to supply, so I breached our agreement. Because you didn't have coffee, your client who would have a meeting at your coffee shop could not have their meeting, which caused them to have loss. Well, that is not foreseeable for me as a coffee supplier. So damages are limited to the extent that they can be foreseeable by the party breaching the agreement. And we saw a similar situation in tort law. Remember, I told you I would be fixing this projector. Someone in the hallway would claim they were damaged by my fixing the projector here. So there's no direct link either. Mitigation. This is specific for contract law. Victims of contract breach, they have a duty to mitigate their losses. They have a duty to keep their losses as low as possible. So let's say you are a landlord. You have a place that you rent to your tenants. Let's say your tenant goes away with unpaid rent. So you were a victim of breach of contract, tenancy breach. You will sue them. But until you get compensated by them, you have to offer your property for rent to others so that you mitigate your loss. You don't keep your place closed and then you will sue for all the amount. So you have to mitigate your loss at some extent. Let's say you are in an employment relationship and you are wrongfully dismissed. You will sue for wrongful dismissal. How can you comply with your duty to mitigate your loss? You were an employee, now you are not anymore because you were wrongfully dismissed. You are now suing for wrongful dismissal. How can you mitigate your loss? Job. Try to find another job. Update your resume. Look for other jobs. It doesn't mean you have to find another job, but at least you have to do whatever you can to try to get another job. And this could eventually accept to return to your former job. Okay, so this is the duty to mitigate. If you are a victim of breach of contract, you cannot go home, lay in the couch, watch Netflix for the whole day. You have to work in a way to mitigate your losses or try to mitigate your losses. Now we have this concept called acceleration clause. So it's a type of a clause in loan agreements, mainly mortgages, that says that if you fail to make an installment payment, the entire outstanding debt will become due and payable immediately. So if you have a car that is financed, or if you have any finance goods, or if you have a mortgage, try to look at your agreement to see if you find this acceleration clause there. And if you are in any type of transaction, you should avoid failing to make an installment payment. In a moment where you have a financial hardship, you would try to avoid, you would fail to pay, let's say, some utility bills or some other things, but not your loans or mortgages with an acceleration clause. Because if you fail, the entire debt becomes due immediately. Does it make sense? So that's the acceleration clause. Liquidated damages. This is a clause in which parties, when they enter into an agreement, they agree on a certain amount that will be paid to the other in case of a breach. This is common in the sponsorship agreements. For those who know or who like a little bit soccer, you know, have you heard about Neymar, Brazilian soccer player? So Neymar is sponsored by Nike. So if Neymar wears any sports gear from other brands, Neymar may have to pay a certain amount to Nike because of the breach. But see, the beauty of this clause is that the victim doesn't need to prove their damages. All they need to prove is that there was a breach. So it's easier for the party, for the victim. As long as there was a breach, that amount is owned to the other party. Does it make sense to you? And now, deposit and down payment. Well, a deposit will not be returned to you, will not be refunded if you change your mind. If you make a deposit in a purchase, in a contract, it will not be returned to you. If it's not going to be returned to you, we can say, in other words, a deposit functions similarly as a liquidated damages clause. Because if you change your mind, that money is retained by the other party. A down payment may be returned to you. But I should also let you know that in real life, people use deposit as down payment and sometimes down payment as deposit, so they mix. But for us in this course, a deposit will be forfeited if the party changes their mind. A down payment will not. So like in my case, I want to buy a new car. I like the car. I see a Porsche. I want this Porsche. I make a deposit. Then I go home. My wife tells me, no, you cannot buy this Porsche. So I will lose my deposit. Because I know this, because I know my wife is a runner at home, I make a down payment. Because if she says no, I will get my down payment back. Okay, but again, as I said, I've seen already offers for cars when they said that the deposit would be returned if the client would not be approved in their credit check. So again, in real life, those are mixed, but for us, they are not. Are we good? Where do you see deposit used a lot? What kind of transactions? Real estate. Real estate usually is 20%, or with the offer, usually you make a 5% deposit with the offer. And if you change your mind, you may lose that amount. Even though in real estate, there are specific rules for the transaction, we should know. Okay, this deposit is different when we talk about the PAT deposit or the rentals, the tenancy deposit. That one is more, that deposit is more similar to a guarantee. The landlord keeps some amount of money, limited to half a month's rent, so that when you return possession to them, they have a guarantee that any damages to the property, they can use that deposit as guarantee. Okay, so that one is different. All right, so now let's look at equitable remedies.
I found this on the web.
Okay, thank you. So equitable remedies, they are remedies that are available as opposed to damages. So in some situations, damages are not sufficient, are not enough. So then exist the equitable remedies. The equitable remedies, if you remember, I told you that they were developed by the Court of Chancery. I told you back in our first lecture, but that Court of Chancery doesn't exist anymore because it merged to the common law courts. However, their remedies are still available and used by common law courts. So first thing is that those remedies, they are discretionary to the judge. The judge, at their own discretion, may award them or not. Because at the end of the day, the judge may always want to award damages, money, monetary compensation, as opposed to other remedies. So what are they? Rescission. Rescission is the first one, canceling. Did we see rescission as a remedy on Monday? For what situation? In what situation is rescission available? Misrepresentation. So when there's a false statement leading to a contract, rescission is available as a remedy. Not always, but it may be available. And what does rescission mean? It means that the contract is canceled and parties are returned to their original position. What is my original position if I bought something from you under a lie? I get my money back and I return the product to you. That's what my original position is. Another equitable remedy is rectification, REC, rectification, correction. So the court may interpret and correct wording of a document. But they will only correct if it's a typo, if it's an obvious error. Courts will not rewrite the intention of the parties. If the intention of the parties is not clear, courts may void the contract. They will not correct. Specific performance. So a party is ordered to specifically perform their obligations. My neighbor and I have an agreement that no one will erect a wall that may block each other's view. So my neighbor starts erecting a wall. I don't want money. I want my view back. I want my neighbor to specifically perform as we agreed. So I will seek in court specific performance order. Injunction, order to prevent someone from breach a contract or someone to stop breaching a contract. So you have to deliver fresh croissants to my coffee shop, but you are delivering raw croissants, not fresh baked croissants. So you are breaching the contract. I'll seek an injunction so that you stop breaching the agreement. Okay. Accounting. Accounting is an order in which the party will need to disclose all their financial dealings, financial records, and they may eventually have to pay out the profits they made, turn over the profits they made. So if my company sells fake shoes, the owner of the brand may sue my company and seek an injunction. So I stop selling those fake goods, and also an accounting order so that all my financial records are disclosed. Any money I have made may be turned over to them. And now quantum merit is payment for partial performance. Well, I'm a construction company. I was hired by you to build your house. I'm in the middle of the construction and you say, hey, stop building. I don't want you anymore. I don't want your company anymore. And you don't want to pay for what I have made so far. So we'll sue you on quantum merit. I want to be paid on the top of damages for the bridge. I may also want to be paid on what I have performed already. That's quantum merit. Quantum merit, by the way, is a Latin expression. Well, those equitable remedies, as I said before, they are discretionary. If the judge understands that they should not be awarded, judge will always rely on damages, monetary compensation. And the party seeking them, they cannot take too long. So my neighbor starts erecting the wall. Within weeks, within days, I have to sue. I cannot wait for months, years. If I do that, those remedies will not be available. Only damages will be available. Okay? So those are the equitable remedies. What else should I talk to you in this chapter? Nothing else. Questions? Comments?